All right, so are you Raul Carino?
Yes, ma'am.
Let's see. Takes me this way. The computer is running very slow. Okay, so Mr. Carino, in cause number 24 DCCR 2350, and we've gone over this before, but let's go over it again, make sure we're all on the same page. You're charged with the first-degree felony offense of aggravated sexual assault of a child from October 5th of 2024. Your indictment alleges that you were previously convicted of robbery, a second-degree felony, January 11th of 2011. And after that was final, you were convicted of possession of a controlled substance, a third-degree felony, August 2nd of 2023. And what that means, and we've gone over it again, is that if you go to trial and you're found guilty, you would be considered a habitual offender, which means your minimum punishment would be 25 years in prison, up to 99 years or life. Do you understand? And I have a new plea bargain rejection that you've signed with Mr. Matuska that looks like it made a small modification in the offer. And it shows that the state has offered, if you wanted to enter a plea of guilty, a 35-year term in prison or a cap of 40 years. I'm sure Mr. Matuska's gone over with that with you. You have every right to reject that and have your case moved to the trial docket. Just want to make sure you understand the possible consequences and your options. You understand all of that. Is there any reason to believe, I know this is Mr. Nichols' case, but is there any reason, any notations about why this would change?
No, Judge. In fact, he said he figured it would be a rejection and it would be reset for trial.
So I want to make sure you understand, Mr. Carino, that once your case gets moved to the trial docket, I'm not going to accept this agreement. It either goes to trial or it's some different agreement unless there's some new information or evidence that your attorney or the state's attorney gets. Do you understand?
Yes, ma'am.
Okay, we'll get it set on the next available trial docket. Mr. Matuska will begin preparation for trial.
Thank you.
Your Honor, just a note, last hearing we had, we had not obtained the media discovery. We have obtained that now.
Okay,
So we have
so you have everything. Perfect. Okay, then we'll get it moved as quickly as we can. Let me get this pulled up. Good morning, sir. You're John Stanley Van Wright. And let me pull your... So it looks like Mr. Van Wright is on probation in cause number 15-23582 for the offense of injury. Hold on. So injury to a child or injury to an elderly? What is, hold
I believe
on.
it's disabled.
Disabled.
Your Honor.
Last choice. My computer's spinning. All right, so he was on probation for injury to a disabled individual, and that was a 10-year sentence that was probated for 6 years. Were there extensions on that?
I think there was a DUI at some point. It was around 2016.
Was what?
Adjudicated. The case was adjudicated and sentenced to another 6 years. Past the original, like the first one came out. I'm sorry, I'm gonna get my notes here so I can tell you the dates. Originally, he was on probation 5/9/16 for a term of 4 years. They filed a motion for the DWI. And at that point, it looks as if the deferred was revoked. And
Right.
he was put on adjudicated probation.
Right.
And that was for a term of 6 years.
Correct. And that was, okay, so that was July, that judgment adjudicating guilt was July 28th of 2020. And that was a 6-year probation starting on that date.
Yes, ma'am.
Okay, so there's been a motion to revoke filed in that case. And alleging the new offense, which is 24 DCCR 2485. And that offense,
That's also injury to disabled.
okay,
Same thing, Judge.
injury to a disabled individual, in that case with an offense date of November 14th of 2024. Mr. Floyd has filed motions asking that I reduce bonds in each case. Is there a bond set at all in that MTRP case at this point, or is it no bond? It should be no bond, I
I
would
think
think.
there's no bond at this time.
Okay, and then in the new case, the bond is set at currently 100,000?
Yes, Judge.
That's correct, Your Honor.
Okay, so we've got no bond and then $100,000 bond. All right, so do you intend to call your client as a witness?
I do, Your Honor.
Sir, the best you can, please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you, sir. You may proceed.
Mr. Van Wright, could you state your name for the record, please?
John Stanley Van Wright.
Okay. And are you aware of the bond that was set and the injury to the disabled?
Yes, sir.
Okay, how much was that?
$100,000.
Okay, can you afford to pay that bond?
No, sir.
Do you have anyone that can help you, family or friend-wise?
Yes, I have a sister-in-law that's willing to put up $3,000.
I need y'all to both kind of speak up just a little bit
Yes,
for
ma'am.
myself as well as the court reporter.
Yes,
I
ma'am.
apologize, Your Honor.
My sister-in-law said she would put $3,000.
Okay, and right now, that's all you could afford?
Yes, sir.
Okay, where are you from, Mr. Van Wright?
I was born in Lafayette, Louisiana, moved to Port Arthur in 1974.
Okay, and so you've lived in Port Arthur since 1974?
Yes, sir.
Okay, who else lives in Port Arthur that you're close to?
My wife and my 90-year-old dad.
Okay, and do you help take care of your father?
I do.
Okay, and you mentioned your wife, does she work outside of the home?
No, she does not work.
Okay, is she suffering financially right now?
She is, yes, sir.
What do you do for a living, Mr. Van Wright?
I'm an over-the-road truck driver.
Okay, and so if you were released on bond, you would have to leave the Southeast Texas area from time to time in order to do your job,
Yes, sir.
correct? And provide for your family. Are you representing to the court that you would come back?
Yes, definitely, yes. I live there. My dad's here, my wife's here.
Okay, and where would you live if you were released?
3125 North Drive, Groves, Texas.
Okay, I'll pass the witness, Your Honor.
No question.
Okay. All right, any other witnesses?
That's it, Your Honor.
Just so everybody is aware and for the record, I'm going to take judicial notice of the court's file in each of the cases. Give me just a second. Right now, I'm just reviewing the probable cause affidavit in the new case, and then I want to take a look at some other stuff real quick, and then I'll. So on the probation case, obviously, we've been here before because it was a deferred probation, there was a motion to revoke filed, it was revoked, and then given an opportunity on straight probation. So there was at least that. Let me. Okay, Mr. Smith, do you have any witnesses?
No, Judge.
Okay, what's your position?
Well, my issue with this whole thing is the fact that he's on probation for this particular offense and then does the exact same thing. On top of the other problems he's had on that probation, he does the exact same thing. He goes, there was apparently some kind of an argument between his wife and a victim, or the alleged victim, at a drugstore. She calls him, he leaves whatever he's doing, doesn't try to confront him verbally, he just walks up and punches a guy who's obviously disabled because he walks with a cane. He's not learned anything from probation, and I just have a hard time with it in this case. I don't feel like I'm gonna wanna continue him on probation on the new case or on the case that he's on with the motion pending.
Your Honor, respectfully, I think that misrepresents what happened. Obviously, we have a different position, and I'm not accusing Mr. Smith of lying. It's just my client has a
I
different
would
take
hope
on it.
not.
I'm sorry?
I would hope you wouldn't be
No,
accusing
no,
me of
he
lying.
said he
No,
didn't.
I'm not. Of course not.
He just says
I
his
just said it was
client has a
misrepresented.
different
Correct.
opinion.
Is
So-
that understood?
Well, I'm just going on what's on the probable cause affidavit.
Okay. Well, my client has a position that's different from what's on the probable cause affidavit.
Okay, that's why we're always here and on different sides of this, so take a step back, take a breath, and so here is, has all the discovery been, I know the probable cause discusses video, has that been turned over in the new case? Do y'all have that? The store
We have
video?
Yes, Judge.
I
Have
do
you?
not have the video, Your Honor.
Okay, so obviously that would be important for you and your client to review. At this time, based on the history of the underlying offense and the fact that we've been here before on a motion to revoke, oh, that's what I was gonna look at, hold on a second. Hold on. So there was the driving while intoxicated is what got us, okay. This is the last time. Okay. In cause number 24, DCCR 2485, at this time, based on the testimony, based on the probable cause affidavit and all of the criterion 17.15, I am going to deny the motion to reduce the bond in that case. In cause number 15-23582, that's the motion to revoke probation case. I will find that I will set a bond in that case. The bond in that case will be set at $100,000. Oh, wait. Why were you in custody? Let me recall that I just did that. Why were you in custody in Lordsburg, or do you know, New Mexico in March of this year?
Yes, Your Honor. He was on a job, driving the truck, and I think it was a weigh-in?
Yes, West.
He stopped at a weigh station, and the warrant was out,
Okay,
and so they took him into custody.
gotcha.
there.
So there wasn't any new offense there or anything like that? He just was arrested on this warrant for the motion or the new case? Okay. All right, so again, in 15-23582, I am going to set a bond. I'm going to order that it be set at $100,000. And then we will get the case set for an announcement to figure out if we're going to go forward on the motion or the trial. We can do that at the next court date. Okay?
Sounds good, Your Honor. Thank you.
Yes, ma'am.
Your Honor, would you mind entertaining special conditions based upon this for probation if he is bonded out?
Yeah, I mean, what are you at? What would y'all be requesting?
Due to what we're being the information we have, we're requesting that the defendant, if bonded out, enroll in anger management and violence prevention. We're requesting that he have no contact with the victim, which is Robert Workman. We're asking that he remain off the premises of the Walgreens. And we also are including, based upon the offensive material, that the defendant not own, possess, or have on his person a firearm or weapon.
Well, he's a convicted felon, so definitely shouldn't be having that anyway. I think all of those are reasonable conditions. So those will be conditions I'll sign for probation. In addition, they will be conditions on if you make bond on the new case, which is 24 DCCR 2485. So there'll be conditions of the bond and conditions of probation on both cases, if that makes sense. Okay, sounds good. You have something for me to sign for probation, at least the probation conditions?
Yes, ma'am.
Thank you. And I'm gonna let them take these real quick so y'all can, and if you'll get it from them so they can make sure, put those as bond conditions, and they'll be in the computer as the bond conditions as well. Okay, we'll see y'all back for the next announcement.
Okay, thank you, Judge. May I be dismissed?
Yes, sir.
Thank you.
Thank you. Mr. Rambin, in cause number 24 DCCR 2280, you're charged with the third-degree felony offense of possession of a controlled substance, MDMA, and that is from May 24th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And are you pleading guilty because you actually did what they've charged you with?
Yes, Your Honor.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Gertz?
Yes, Your Honor.
Do you fully understand them?
Yes, Your Honor.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, Your Honor.
And it looks like the agreement that you've reached on this case is for a 10-year deferred adjudicated probation. There would be a $500 fine. There would be dismissals in cause numbers 24 DCCR 2278 and 24 DCCR 2279. There would also be a dismissal of the motion to revoke in cause number 23 DCCR 1532. You would be continued on probation in that case, and you would be, okay, so I don't think we can do ISF both tracks, correct?
Why not?
We can't, they quit letting us do that. You have to pick a track, one track only. So it kind of depends. A couple things what we've done is, if there's both things needed, doing the cognitive track of ISF with JCDI as aftercare.
I think I'd sure like to do it that way.
Instead of,
preferably.
because
Yeah,
if you
'cause
do
He's
it,
been clean for a long time now and has been to rehab already, so I'd really rather him be on cognitive
that makes more sense to me.
and
Okay, it's okay.
follow it up with JCD.
Yeah,
That's
okay.
good.
So with everyone's permission, then I'm gonna make that notation on the agreed punishment recommendation page.
That's fine, Judge.
There's no objection.
So we're gonna do ISF cognitive with JCD. So you understand what we're saying is ISF, we used to could send someone for both tracks. That's not available anymore. So you'll be ordered, if I follow this agreement, to go to the cognitive track of ISF, and then when you're out, you'll be ordered to enter and successfully complete the JCDI program, which is an outpatient drug treatment program. Do you understand?
Yes, Your Honor.
Okay. See, do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, Your Honor.
State tenders number 1.
Judge, we have no objection.
It's admitted. Is there any evidence that Mr. Rambin is not competent?
No.
So if he's already on probate, is there any reason to do a pre-sentence report?
State would, is not opposed to waiving that PSI under these
And
circumstances.
we're fine waiving it too. It's sort of a hyper-technical question, Judge, but if, my understanding is the 1-year probation that he was on has essentially been extended by the motion to revoke probation. So I think as a technical matter, when the motion to revoke probation is dismissed, that probation sort of goes away.
That's my understanding.
So the one that he was on probation for was a lesser, I guess?
Has now expired, yeah.
And it was because it was pled down to a misdemeanor, is that why?
I don't know why it was in here.
I just, the
Well,
probation department told me that it was how they termed it was timed out.
Timed out. But I think it's held over because of the motion to revoke probation alias capias.
That's my understanding.
Yeah, but I guess my question, let me, hold on. Hold on one second. So it was pled down to the lesser included offense of a Class B misdemeanor fleeing a police officer for a 1-year probation. So yeah, that one will be gone, and then he'll be on probation now on this one.
Okay.
Okay, yes.
Thank you, Judge.
And that's everybody's understanding, yours as well. Okay. Then at this time, Mr. Rambin, I'm going to find that you entered your plea of guilty in this case freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney. Going to defer all proceedings and place you on probation for 10 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of this probation, which include you will be ordered to enter and successfully complete the cognitive track of the ISF program, and then you will be required to enter and successfully complete the JCBI program after you are released. If you do everything you're supposed to do on this probation, today is an excellent opportunity for you. You're getting a couple cases dismissed, you're off the misdemeanor probation, but you're now on a 10-year deferred probation on a 3rd-degree felony, which means if you violate any condition, you can be brought back into court. Things will look a whole lot different than that misdemeanor, because you'll be then, you could be found guilty, which gives you the felony conviction on your record, and sent to prison for up to 10 years. Do you understand?
Yes, Your Honor.
I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. And I think that is it. All right, good luck to you, sir.
Thank you, Your Honor.
There's a tab that's locked up.